I have several Indian American clients whose parents have property in Hyderabad or anywhere in Telangana, and their parents have passed away without writing a will. So to take the typical example, they have father, mother, son, daughter. The father passes away. This property in his name, either a flat, plot of land, a house, and so on. And now the mother and the children, they kind of want to sell the property, or they just want to change the names in the property records, and or they're trying to sell it, and a buyer comes and says, I like the property, I'd like to meet the owner. They say he's passed away. The buyer says, well, I don't know who the actual legal heirs are because there's no will in place. So what do you do in that kind of a situation? So what you need to do is you need to obtain something called a legal heir certificate from a local court where the property is located. And by a certificate, I don't mean it's kind of a certificate. It's actually a court judgment that will declare, the mother and the kids as the legal heirs of the person who's passed away. The process takes about 3 to 6 months. The court fee involved is about 0.5% of the market value of the property. By market value, I don't mean the value in the market. It is the government value that is maintained by the sub-registrar. So if the government value maintained by the sub-registrar is 1 crore, then the value of the or the court fee that you'll have to pay is 50,000. In terms of documents, what you would need is your Aadhaar cards or any kind of document showing that the mother and the children are related to the father. It could be a PAN card, it could be an Aadhaar card. Passports, I don't recommend because you guys are living abroad. Don't give your passports to the court because you'll have to give originals. So your birth certificates, 10th class certificates, so on. So these are identification documents. Apart from these identification documents, you also need to file documents with respect to the properties that the deceased person owned. So you may have to file the certified copy of the sale deed. You may have to file the EC, the encumbrance certificate, which you'll get at the Me Seva. With both, you get the certified copy and the EC you get at the Me Seva. You may have to file a market value certificate that you will get with the sub-registrar. And you never have to come to court because if you have, say this between the son and the daughter, if you are in Texas, but one of you guys is in India, then you can just give a general power of attorney to her, so that, or him, depends on who's here, and that person can represent you and the mother in court. They'll have to come to court only once. But if you are executing the general power of attorney, then make sure that the document is actually notarized there, and once it's sent here, you'll have to get it validated here before the sub-registrar before it can be filed in court. And here's a tip. Keep the envelope in which you send the document to India, because when you try to get it validated here before the sub-registrar, before the district registrar is going to ask you for the envelope in which the document came to India. Follow for more estate planning tips for Indian American families in Texas.